Debating the Need for a Bill of Rights, James Wilson and John Smilie. One of the major points of contention in the debates over the Constitution was a Bill of Rights guaranteeing citizens certain liberties. Pennsylvania held a convention in November to consider ratifying the Constitution. Almost immediately, one of the major points of contention was the lack of a Declaration of Rights guaranteeing certain liberties to citizens, as this November 28, 1787 exchange between James Wilson, who signed the Constitution, and John Smilie shows. Pennsylvania ratified the Constitution on December 12th, 5 days after Delaware was the first state to do so. James Wilson. Mr. President, we are repeatedly called upon to give some reason why a Bill of Rights has not been annexed to the proposed plan. I not only think that enquiry at this time unnecessary and out of order, but I expect at least that those who desire us to show why it was omitted will furnish some arguments to show that it ought to have been inserted, for the proof of the affirmative naturally falls upon them. But the truth is, sir, that this circumstance, which has since occasioned so much clamor and debate, never struck the mind of any member in the late convention till, I believe, within 3 days of the dissolution of that body, and even then, of so little account was the idea, that it passed off in a short conversation, without introducing a formal debate or assuming the shape of a motion. For, sir, the attempt to have thrown into the national scale an instrument in order to evince that any power not mentioned in the Constitution was reserved, would have been spurned as an insult to the common understanding of mankind. In civil government it is certain that bills of right are unnecessary and useless. Naught can I conceive whence the contrary notion has arisen. Virginia has no Bill of Rights, and will it be said that her Constitution was less free? John Smilie. I beg leave to observe, Mr. President, that although it has not been inserted in the printed volume of state constitutions, yet I have been assured by Mr. Mason that Virginia has a Bill of Rights. Wilson. Wilson. I do not rely upon the information of Mr. Mason or of any other gentleman on a question of this kind, but I refer to the authenticity of the volume which contains the state constitutions, and in that Virginia has no Bill of Rights. But, sir, has South Carolina no security for her liberties? That state has no Bill of Rights. Are the citizens of the eastern shore of Delaware more secured in their freedom or more enlightened on the subject of government than the citizens of the western shore? New Jersey has no Bill of Rights. New York has none. Thus, sir, it appears from the example of other states, as well as from principle, that a Bill of Rights is neither an essential nor a necessary instrument in framing a system of government, since liberty may exist and be as well secured without it. But it was not only unnecessary, but on the occasion it was found impracticable, for who will be bold enough to undertake to enumerate all the rights of the people? And when the attempt to enumerate them is made, it must be remembered that if the enumeration is not complete, everything not expressly mentioned will be presumed to be purposely omitted. So it must be with a Bill of Rights and an omission in stating the powers granted to the government, it is not so dangerous as an omission recapitulating the rights reserved by the people. We have already seen the origin of Magna Carta, and tracing the subject still further, we find the Petition of Rights claiming the liberties of the people according to the laws and statutes of the realm, of which the Great Charter was the most material. So that here again recourse is had the old source from which their liberties are derived, the grant of the king. It was not till the Revolution that the subject was placed upon a different footing, and even then the people did not claim their liberties as an inherent right, but as the result of an original contract between them and the sovereign. Thus, Mr. President, an attention to the situation of England will show that the conduct of that country in respect to Bill of Rights cannot furnish an example to the inhabitants of the United States, who by the Revolution have regained all their natural rights, rights, and possess their liberty neither by grant nor contract. In short, sir, I have said that a Bill of Rights would have been improperly annexed to the federal plan, and for this plain reason that it would imply that whatever is not expressed given, which is not the principle of the proposed Constitution. Smilie, the arguments which have been urged, Mr. President, have not, in my opinion, satisfactorily shown that a Bill of Rights would have been an improper, nay, that it is not a necessary appendage to the proposed system, and has been denied that Virginia possesses a Bill of Rights. I shall, on that subject, only observe that Mr. Mason, a gentleman certainly of great information and integrity, has assured me that such a thing does exist, and I am persuaded I shall be able to a future period to lay it before the convention. But, sir, the State of Delaware has a Bill of Rights, and I believe one of the honorable members who now contests the necessity and propriety of that instrument took a very conspicuous part in the formation of the Delaware government. It seems, however, that the members of the Federal Convention were themselves convinced in some degree of the expediency and propriety of a Bill of Rights, for we find them expressly declaring the writ of habeas corpus and the trial by jury in criminal cases shall not be suspended or infringed. How does this indeed agree with the maxim that whatever is not given is reserved? Does it not rather appear from the reservation of these two articles that everything else which is not specified is included in the powers delegated to the government? This, sir, must prove the necessity of a full and explicit declaration of rights, and when we further consider the extensive, the undefined powers vested in the administrators of this system, when we consider the system itself as a great political compact between the governors and the governed, a plain, strong, and accurate criterion by which the people might at once determine when and in what instance their rights were violated, it is a preliminary without which this plan ought no to be adopted. So loosely, so inaccurately are the powers which are enumerated in this Constitution defined, that it will be possible, without a test of that kind, to ascertain the limits of authority, and to declare when government has degenerated into oppression. In that event, the contest will arise between the people and the rulers. "You have exceeded the powers of your office, you have oppressed us," will be the language of the suffering citizens. The answer of the government will be short: "We have not exceeded our power, you have no text by which you can prove it." Hence, sir, it will be impracticable to stop the progress of tyranny, for there will be no check but the people, and their exertions must be futile and uncertain, since it will be difficult indeed to communicate to them the violation that has been committed, and their proceedings will be neither systematical nor unanimous. It is said, however, that the difficulty of framing a Bill of Rights was insurmountable. But, Mr. President, I cannot agree in this opinion. Our experience and the numerous precedents before us would have furnished a very sufficient guide. At present there is no security even for the rights of conscience, and under the sweeping force of the sixth article, every principle of a Bill of Rights, every stipulation for the most sacred and invaluable privileges of man, are left to the mercy of government.